the driver of that could head up to the registration. All right, is this any better? Okay. I was asked to make a quick announcement. There's a blue Mini Cooper in the garage with Michigan plates. If the driver of that could head to the registration desk and check in there, that would be great. I think we'll get started in just a minute or so. Thanks. All right, let's go ahead and get started. This is the panel on gender and complementarity. My name is Anna Cave. I'm the Principal Deputy in the Office of Global Criminal Justice at the State Department. I follow in the footsteps of a couple of people who you've heard from today, Ambassador Rapp, Diane Orntlicher, and Jane Stromseth. I cannot hope to fill their shoes, but I do have the honor of coming after them in the office at the State Department. I'm going to just say a few words about my work and from a policymaker's perspective, and then I'm going to turn it over to this esteemed panel to really talk through a couple of questions. And we're going to try to keep it fairly conversational, and then we'll have a few moments, a few minutes at the end, 20, 30 minutes at the end for questions and answers. So let me first just introduce our panel. Here on my right, Daniela Kravetz is an international criminal justice and gender practitioner. She's worked with UN Women in Colombia and was a former prosecutor at the ICTY. Next to her, Amanda Rawls, director in the Africa Division of the American Bar Association in the Rule of Law Initiative, with experience in DRC and Liberia. And next to her, Patricia Sellers, a special advisor on international criminal law prosecution strategies at the Office of the Prosecutor at the International Criminal Court. She's an esteemed international human rights and criminal law scholar and practitioner. She's advised the UN High Commissioner for Human Rights and served as the gender legal advisor for ICTR and the ICTY. And finally, at the end here, Julissa Mantilla is an international consultant specializing in transitional justice with a gender approach. She's was a member of the Peruvian Truth Commission, where she invested cases of sexual violence and has served as a legal expert at the Inter-American Court. She is currently a professor at the Catholic University in Peru. So that's our panel. I'm just honored to be here among them. They have a rich wealth of experience in this field. So I thought I'd just start very, very quickly with a brief overview, like I said, from a policymaker's perspective that comes neatly on the heels, I think, of what David and Juan talked about over lunch. And that is, I'd start with maybe the bad news. I think from my perspective, I've worked mostly in Africa from the White House and formerly in this office as well, that during an ongoing conflict, most senior policymakers really do consider justice, I would say at best, a quick fix tool to deter would-be perpetrators, to deter perpetrators of doing further violence, something to be grappled with, again, at best, and at worst, an obstacle to overcome, or perhaps just an afterthought. I think they assume that people want first security, then they want basic social services, and down the road, justice would be nice. And I do think, as David said, that is understandable. I think that he presented a pragmatic and more nuanced approach than I think our general gut reaction to that usually is. But I think it's important to remember that is not necessarily what victims and survivors always want. And the fact is that many women and men do want justice. Maybe not today, but they want it. And there are things that we can be doing now to lay the groundwork for that in the future. One of the lessons that I think I learned from Ambassador Rapp that I will always carry with me is that we need to be that voice for the victim. This community of scholars and practitioners need to carry that message to other senior policymakers who are more focused on the security, on the development. And I would just throw out a couple of anecdotes of where that's been true in my work. The first is our first mission to Eastern Congo after Secretary Clinton had made a historic visit in 2009, and I went with Professor Orntlicher, and we were in Goma, and a group of women came to meet with us, and there was a young girl, a 9-year-old girl, who was absolutely beautiful but heartbreakingly sad, and she came with her father to tell us that she wanted justice. The other women there wanted justice. Down the street at Panzi Hospital, there were women that took advantage of the programs that ABA supports and others to ask for justice. And then shortly thereafter, we were at the first review conference in Kampala, and there was a group of over 30 women, mostly from Africa, who was there to lobby policymakers and lawyers and the international community to say we want justice. And so I think that's our role here. And we've seen the legal field move very quickly, actually, I think, in the last 2 decades. It feels slow at the time, but I think that's actually fairly quickly in this front. And we now have a legal foundation, which we'll talk about, to help push and propel that desire forward in a more meaningful way. And I would just say that I was just sitting in the office of a regional bureau colleague of mine who had experience in Rwanda, experience with the ICTR, and we were talking about how you find funding for yet another expensive court. And he said something that caught me off guard, frankly, but was a positive indication that we're moving in the right direction. And that is, he said, I'm beginning to wonder if accountability, if breaking the cycle of violence by ending impunity is really the linchpin of stopping those cycles of violence. And I was taken aback to hear that from someone I didn't necessarily expect to hear it from. So perhaps we're making progress on that front. So with that, I think I'll turn it over for our first question to Patty. And the question we thought we'd start with, which I alluded to, is that we have seen quite a bit of movement in the legal, in the jurisprudence of combating sexual violence as an international crime. And the question we thought we'd center our first discussion around is, how can we better identify the gender dimensions of mass crimes that are often inherently gendered, even if not obviously so, in the prosecution, at the prosecution stage? And kind of a concurrent question with that, what are the effects of the different kinds of individual liability in the jurisprudence of the ICTY and the ICTR versus the Rome Statute? And with that, I'll just turn it over to Patty to kick us off, and then we'll have a little bit of back and forth and a few additional questions.
Thank you. This is such a weird mic. I'm hearing an echo of my own voice. Well, the first thing in terms of looking at crimes and understanding if they're inherently gendered, I think we have a problem because we're always looking for the crime of rape, the R crime, as opposed to understanding that the crimes in and of themselves are gendered. There is no way that the civilian population and crime against humanity, which consists of an attack against the civilian population, isn't inherently gendered. Even if it's only against men or only against women, we should look at that with a gendered focus. Within the latest decision of Kravetz, you won't find the allegation of a separate crime of rape. What you do is look under persecution, look at the gendered nature of persecution, including its inclusion of sexual violence, to understand that crime against humanity. And the same can be said in terms of the genocide within the Kravetz judgment. Even though the genocide for the municipalities and the detention center was lost, one could look at the Srebrenica massacre. And looking at other jurisprudence that comes out of the Srebrenica cases, I've spoken about this before, the Srebrenica, in quotes, genocide was inherently gendered, looking at what happened to the men and the boys, what happened to mainly the women who were transferred out. There's been discussion in several of the cases of what happens to the reproductive capacity of that community. And so not to understand the very gendered nature of crimes against humanity, of war crimes, of genocide, is really not to fully understand the nature of that crime and the extent to which its prohibition has incurred. And I would lastly say for that question, not to do so is really to renege on our use cogent obligations in terms of preventing that crime or punishing that crime whenever it occurs. To your second issue, in terms of liability, this week with the delivery of the Kravetz indictment and the Bimba indictment by the ICC, I've had people ask me, well, do you think it was a conspiracy that they both came out in the same week? And I said, it's a pretty good conspiracy, you know, or was it finally an alignment of the stars that they both came out in the same week? Well, I would say what's most important is looking very closely at those cases, not necessarily for the substantive underlying sexual violence, all that is extremely important, but looking at the liability modes that were used in order to make that sexual violence attributable to the accused. Within the Bimba case, it is the first time in international criminal law, to my knowledge, that command responsibility of someone who was a perpetrator from a third state has been found, has been convicted based upon sexual violence that was part of just the modus operandi, the normal way that his troops were doing business. It's not rape is a weapon of war. You can't take the rape away from the murder, away from the pillaging. This is how the MLC acted. As a matter of fact, their actions were relentless and so consistent that the trial chamber looks at that as seeing Mr. Bimba of having effective control over his troops. They always acted in a manner that was similar in order to get the functions that they wanted to, clearing out the towns by rape, by murder, and by pillage done. And so the command responsibility doctrine, which is laid out quite beautifully in Bimba, really talks about his command responsibility, his effective control, his ability to have punished or prevented, and the reasonable means necessary. The sexual violence is not separated out as if it were done by renegade soldiers, if it were a frolic and detour. It really was part of the actions of the MLC. When one compares that to the other cases that have come out of the ICC, the International Criminal Court, Katanga or Chu, we realize that due to the liability theory that was charged under Article 25(3)(a), which would have meant that the sexual violence had to be part of what was planned to occur for the accused to have been liable, that none of the sexual violence has ever been the basis of a conviction. And the difference is that under the command responsibility liability doctrine, it wasn't what the commander planned to occur. It's what the commander knew, and in this case, it wasn't should have known, it's what the commander knew, the court said, and what the commander did not punish nor prevent. So I think looking at liability modes as they relate to sexual violence are extremely important. I won't take more time, but there's certainly another analogy or another analysis that can be made with the liability modes of Joint Criminal Enterprise 3 for the Kravetz judgment, in which sexual violence was also picked up under persecution.
Does anyone have anything to kind of respond to on that before we turn to our next question? All right. So we're going to turn next to domestic capacities. We have the international jurisprudence that Patty has talked about and others this morning. But now turning to domestic capacities, I would just note that just in my time of working on cases, and particularly in Central Africa, I do think that we're seeing some small signs of progress in this front. If you had told me 6 years ago that we'd actually see investigations and prosecutions of mass rape in the domestic Congolese system, I probably would not have believed it. But in fact, we are. We saw that in the 2011 Fizi mass rapes of 50 women and girls, in the 2012 Minova rapes, where 125 women and girls were raped, And then even in a single perpetrator case, but of a very senior level general in the Army, one that Secretary Clinton raised, the Security Council raised, Ambassador Rapp and I raised numerous times. General Kakwavu, after about 6 years, was actually convicted in 2014. So we're seeing some small signs of progress, I think, but I don't want to overstate it. All of those investigations and prosecutions had serious problems and serious flaws. So I wanted to turn it over now to Amanda and Julissa to talk about how we assess and enhance the domestic capacity and the willingness to investigate and prosecute conflict-based SGBV crimes.
Yeah. Hi. So I'm Amanda Rawls. I've been working with ABA Rowley here based in Washington for about 3 years now. ABA has a program in DRC that's our longest running program in Sub-Saharan Africa, focusing largely initially on combating impunity for sexual violence. And that program started in 2008. When I was thinking about this panel, I was feeling fairly inadequate to the task of talking about the capacity challenges because I've been based here. So I've been reading reports and visiting the field, but I'm not personally training prosecutors. But I was in Goma the week before last, and so I sat down with our program directors and put the question to them, sort of after many of them have been working on the program since 2008. What have they seen change? And what do they see as those capacity challenges? And for the most part, they would identify capacity to prosecute as something that has indeed improved. We conducted trainings for prosecutors on the content of the law and their obligations under the law, the components of putting together a successful prosecution, how to work with the police investigators. And there are individual champions, I would say, that they've identified in both the civil courts and the military justice system. I think particularly the military justice system has been surprisingly strong in prosecuting a number of these cases. They would identify the capacity for investigation as the much bigger challenge. And that's everything from the individual police officer's capacity, the OPG, so the judicial police who go out and investigate cases, back everything from the knowledge of what they're looking for, how to collect evidence, how to preserve evidence, to the basic logistics, the motorcycles or cars or fuel to go out to the field, the money to eat while they're out there. And quite often when they're faced with a mass crime, there is no evidence collection stage. The extent of the investigation is talking to people. So you have a lot of testimony, but very little concrete evidence to back up the testimony that's been documented. The capacity building, I guess, that we try to do around this is primarily combining the knowledge base for the police in terms of what are some techniques for collecting evidence and for interviewing witnesses and for approaching people who were traumatized with those logistics. So how do you actually get out to the field? How do you spend enough time there to talk to the witnesses as well as the victims? How do you create a space where people feel safe speaking to you about what happened to them? It's really hard to separate the capacity from the will questions. So while there are good indications of national level political will to prosecute these cases or investigate the cases in terms of national action plans and circulars that create specialized prosecution cells or specialized police forces, if you dig just a little bit deeper, there's not much evidence of the actual will to implement those mechanisms. So to make those prosecution cells operational, to staff them or to fund them or to give them space to work. And while when there is sort of institutional capacity demonstrated, for example, the police have the specialized police units for protecting women and children, it's difficult at times to identify individual officers who have the personal will to go above and beyond, to actually go out to the field, to figure out how to get there, to collect the evidence, to figure out how to spend the time to talk to the individual victims, particularly when they have to push back against their supervisors, to spend the time and to spend the money and the resources. So a lot of the capacity building, and for better or for worse, is a matter of investing considerable financial resources and enabling people to do those jobs when there are the individuals with the personal will. I think another group of people, we often focus on the prosecutors and the police, but there's a lot of will at the community level to do this investigation and do the evidence collection while they're waiting for the police to arrive, or while they're waiting for the prosecutors to arrive. And so I think we would suggest that a considerable benefit could be derived from focusing more on, particularly in atrocities situations in rural areas where there is no police immediately there, so you can't call 911, focusing more on the capacity of the community organizations and the community leaders to preserve evidence, to document what the prosecution will need when they eventually get there. I think we may talk more about Maneuver later on, but in some of these cases, the investigation phase happens such a long time after the crimes themselves that you need the people in the community to be knowledgeable and skilled to keep everything, to prepare everything for when that eventual prosecution phase takes place.
Thank you. Well, as you mentioned, I was part of the Peruvian Truth Commission, and when we finished our report in 2003, we found 527 cases of women victims of rape. I'm talking 2003. Now, 2016, we only have less than 20 cases on trial, not one sentence. So the first thing that is very obvious is that impunity is a rule in the case of sexual violence. And after that, in the present moment, I'm joining some cases as a legal expert witness, 3 or 4 cases I'm going to go on trial last year and this year. So I was start asking myself, and I said, okay, I don't want to focus only in the general difficulties to investigation or violations, but for instance, the Ministry of Defense doesn't want to give the information, we don't have evidence of that. And I think that the first question, or the first challenge, is to understand that many people, I mean, I'm talking about lawyers, prosecutors, judges, don't understand that gender is a valid approach to study human rights violations. I don't know if you allow myself, I don't know how many lawyers do we have here. All of you are lawyers, many lawyers, a lot. Okay, how many of you have taken a course on gender and law in the law school? 1, 2, 3. Okay. Imagine in the general prosecution office or the judge's office. These are the first things. When you become a lawyer, you have to take labor law, tax law, criminal law, whatever law you want, if you want to be a lawyer. But you don't have the obligation to take gender in the law. And this is the first message that the university and the school gave us to all the lawyers. So when you go to trial and you start with the cases, and I'm going to talk the specific experience that I had last year and this year, it's not only about lack of evidence, it's not only about how difficult it is for women to talk. It's that the criminal proceeding have been designed thinking about the specific individual, these women that come to a trial. But in the case of Peru, we're talking about women to belong to communities, indigenous communities. So the way of looking at life is different than the individual. So many women, it was very difficult for them to talk. But when they want to talk and they want to go to trial, there are 2 groups of people who oppose to that. First of all, husbands, because they feel ashamed. They don't want anybody to know that their wife was raped. And second, the community, because they don't want to be known as their very community. So imagine with these difficulties. And I'm going to tell you a story. When I was in the former case I went in Peru, I entered. Since I'm a lawyer, I'm working with gender for a long time, I start counting people. We were 15 people in this court, you know? I'm talking about prosecutor, lawyer, defendants, the secretary, etc., etc. Well, 15 people. 12 men and 3 women. One of them, me, the expert witness, I went only once. one of the 3 judges, and the secretary. So courts are not a space designed or thought for women. The other thing is to understand, and this is a problem when you mention about women ask for justice, of course they ask for justice. The question that we should ask themselves is what means to have justice. I'm talking in the case of sexual violence, in the case of Peru, that they found 117 children born after rape. And we're thinking about the individual, the proceedings, but we don't think about these children born after rape. Where are these children? They have to have them, they release them, what's going on there? But the criminal proceeding is not thinking about that. And the other thing is that when women, in the cases of our conflict, when husband died, women go to ask for justice, they have to go with their children. And the court doesn't have, they care for children, and the court is not a space for children. So when they have these women to go for ask for justice, what they are supposed to do with their children? These kind of things are not in the mind of the prosecutors, of the judges, of the criminal lawyers. And another thing is that how the rules of evidence and proceedings are so fixed, even though we have inter-American courts advances or whatever, there's some specific things that the law doesn't think about it. And I'm going to tell this case. This is a case of a woman. She was raped during detention, several rapes, during the 2 or 3 days that she was under detention. She got pregnant. She had a child, a daughter, after, it was in the 90s, and the trial was last year. Can you imagine? After that, she went to court. I was there, it was the defendant, the lawyer, etc., etc., etc. So the judge ordered a DNA test. And then I said, okay, this is logical to have a DNA test. But the daughter said that she doesn't want to know who her biological father is. So she doesn't want to go for the DNA test. So the defendant's lawyer said, okay, this is the proof that she's lying. That will be right. So I don't know what's going on now, but the lawyer of the case told me last week that we are in a big risk. They are in a big risk of losing the case because the victim of rape doesn't want to go because the daughter doesn't want to go. So it's like you push women, not push, you say you have to dismount, you have to fight the complaint, go, go, go. And when she's there asking for justice, her daughter doesn't want. So she's in the middle, okay, I'm going to be a good mother, I'm going to be a victim of rape, okay, but the judge and the court and the prosecutor and the defense don't care about that. So I think the main challenge is to start thinking criminal proceedings with a different point of view.
Is this working? Okay. Amanda, about maybe the Manova case, I think that's an interesting case study about some of the challenges that we're still facing. You mentioned the Manova case.
I don't know to what extent the folks in the audience are familiar. Hands up if you know what Manova is. David. Okay, so I'll probably get the years wrong, but basically some groups of battalion, I guess, of the Congolese army in retreat from trying to fight against a rebel group raped a bunch of women in a place called Manova. And there wasn't initially a big push to investigate the crimes. And then about, I don't know, maybe a year later, there was a push to investigate the crimes coming partly from, or largely, I guess, from the international community. And my organization was very interested in supporting the investigation and supporting the prosecution of the cases as advocates for the victims. We had gone out and spoken with a number of the women who had been raped. By the time the prosecution and the investigation phase started, the army had sort of won over this rebel group. And so rather than being in retreat, they were sort of heroes because they had, M23 as a rebel group, they had sort of won against the M23, which decreases the motivation of people to prosecute them for these rapes that had happened a long time earlier. This is a very sort of superficial telling of the story, but these are the basics. In collecting the evidence, again, as I said before, there was a lot of taking testimony, but not a lot of evidence beyond the testimony of the women and the testimony of witnesses. And because it was an army group that had come through town that people didn't know on an individual basis, it was very difficult for women to say which of the soldiers had attacked them. So to identify individual perpetrators. There was, the determination that was made in the trial was that there was not command responsibility. And it was our reaction to the verdict. So in the end, 2 of the, I think it was 38 soldiers that were accused, 2 of them were convicted on rape charges, but the others were acquitted on the rape charges. There were some smaller convictions for looting and things. But just focusing on the sexual violence piece, 2 seems like a very small number of convictions to get. And so I think people were very disappointed that that was the outcome. However, our attorneys had to concede the point that it was the correct legal outcome based on the evidence that had been presented at trial. And so in some ways, it's a bit of a victory for the Congolese military justice system in the sense that they did make the right decision based on the evidence that was there at the trial, but it reveals so many weaknesses in all of the lead up. So everything from kind of mundane turf wars and infighting between the international NGOs trying to support the case to the reluctance of the military to prosecute quickly or to investigate fully. The type of court in which the case was brought was an operational military court, which is a court that lacks an appeal option. So there was a whole separate argument about whether or not the process itself was constitutional. I think it was our position that probably the wrong decision was reached on that, in the sense that the case was allowed to go ahead in that tribunal. So a number of weaknesses that came up in terms of things like victims protection. I think it was another example of ways where we have made some inroads. So the victims and the witnesses were allowed to testify anonymously. They were allowed to remain veiled. And elements like that are designed to protect their identity during the proceedings. Those things have sort of caught on in the Congolese justice system. So that was a win. Stop there.
On this question before we move on. All right. And then we'll be sure to leave plenty of time for questions and answers at the end. So for our third question, I think we're looking now at the intersection between the international regime and the domestic prosecutions. And the question here that we'll discuss is, what has been the impact of prosecutions of sexual violence crimes in the international courts on domestic efforts to seek accountability for such crimes? Daniela, I think you're going to talk to us about the ICTY examples, and then I'll turn it over to Julissa to talk about the Inter-American Court.
Okay, thank you. I'm a little hoarse, but I hope my voice carries me. I think that in relation to this question, the experience of international courts in prosecuting sexual violence constitutes a very compelling example of how the work has been done at the international level can be used at the domestic level to promote better accountability outcomes. In particular, the work that has been done by the ICTR, Special Court of Sierra Leone, and more recently by the ICC in this field, has helped to develop a very rich body of principles and approaches that are directly relevant for national jurisdictions that are currently struggling with some of the challenges in prosecuting these crimes and are seeking to improve their accountability outcomes. In the case specifically of the ICTY and ICTR, the Office of the Prosecution in both courts carried out very extensive and in-depth legacy processes where practitioners from the court looked at what had been done well in terms of prosecuting these crimes, and also looked at what had had gone wrong, or what could have been improved in their cases. In the case of the ICTR, the insights that were obtained from this legacy process were published in 2014 in the form of our best practices manual on prosecuting conflict-related sexual violence. And in the case of the ICTY, next month, Oxford University Press will be publishing a publication called Prosecuting Conflict-Related Sexual Violence at the ICTY, which contains some of the insights that resulted from this legacy process. Now, in terms of these insights, the most obvious aspect of this legacy of the international courts that's useful at the domestic level is, of course, the case law that has been developed, both substantive and procedural, which can be used and is being used at the domestic level to support the prosecution of these crimes. But there's also a less visible aspect of the work and of the insights that have come out of these legacy processes that are as relevant, and I would say even more relevant, to improving the domestic accountability in this field. And these are the more policy-focused and operational aspects of the work of these courts. And by that, I'm referring to the key insights that have been developed by these courts in terms of confronting some of the common challenges that are encountered when prosecuting these crimes and developing strategies to address them. Oftentimes, when we think about developing a national capacity to prosecute these crimes, we think about training in terms of providing legal training on modes of liability, on elements of international crimes, which is all very important. But in my experience, it's insufficient to ensure better accountability outcomes at that domestic level. What is really key and what has come out of these legacy processes is the importance of focusing on the more intangible aspects of prosecutions. And by that, I mean focusing on how to address and overcome some of the prejudicial attitudes and misconceptions that those who are working in the cases have towards sexual violence crimes. I'm talking about prosecutors, investigators, judges as well, and defense counsel. And how do we improve the approach that these practitioners have towards victims and towards these crimes? How do we also improve the institutional strategies that are adopted by prosecution offices at the domestic level so that attention is paid to these crimes consistently over time, and that these are not only special cases that are only prosecuted when there's international pressure? And also focusing on how we change the institutional culture and how do we ensure not only gender equality within domestic prosecution offices, but also ensure how we appoint persons in management positions who are gender competent and who are committed to moving issues forward, who are committed to a gender agenda within the office and to maintaining the attention and focusing resources on prosecuting these crimes. And it's insights that have come out from analyzing these questions, which are quite tough questions, by the international courts, which I think are particularly relevant to moving forward the accountability dialogue at the domestic level. And I think that unless domestic prosecution offices start focusing on these issues more seriously, it is going to be difficult to move forward on these issues. Specifically focusing on the ICTY experience and the prosecuting sexual violence project that will be focused and will be published next month, there are a few fundamental insights that have come out of that legacy project, which I think are particularly relevant for domestic jurisdictions. And I'm just going to mention them very briefly because I know we're short of time. The first one has to do with the importance of accurately characterizing sexual violence crimes as violent crimes in order to avoid some of the common misconceptions of seeing these crimes as incidental, disconnected from the broader context of mass atrocity or as private acts. In these misconceptions, we've seen tend to negatively impact on criminal investigations because they lead prosecutors and investigators to discount the seriousness of these acts and not focus the necessary resources and time to investigating these crimes. And these misconceptions also lead prosecutors to miss the connections between sexual violence and the broader context of mass atrocity that they're investigating. A second key insight is the importance of adopting a witness-centered approach from the start of the investigation all the way through the trial, tailored to individual needs of victims in order to create an environment that enables bringing forward evidence of these crimes. And the third key insight that has come out of this legacy work is the importance of adopting strategies that are focused on keeping the attention on these crimes in a prosecution office over time. And the different strategies have been adopted at the international level, everything from going from written policies that are enforced in the offices to establishing focal points, gender focal points within the office, and also ensuring the appointment of gender competent managers in senior positions. But these are some of the key insights which are not necessarily linked to the case law that has been developed by the courts, which are, I think, are key to analyze and consider in terms of the implementation at the domestic level. Just one last remark is to say that in addition to the publication of this book that I said is coming out next month by the ICTY, a prosecuting sexual violence network has been created within the International Association of Prosecutors at the end of last year, and with the support of the Office of the Prosecution of the ICTY. And the purpose of this network is really to establish a forum of exchange among prosecutors, both at the international, but mostly focused at the domestic level, in order to, and my voice is going, in order to promote more progressive approaches to domestic prosecutions, exchange best practices, and simply exchange also information and approaches regarding some of the challenges that are being confronted at the domestic level. And this network is going to start working and operating this year, so something to look out for. Well, concerning the International Court, I have to say that I'm glad that finally we have a women judge in the General Court. Mrs. Julissa already was started this year. I think it's very important to have this. And in the case of the sentence, I would like to mention, well, as you know, the Inter-American system started in 1969, but it was until 2006 when we had the first case, the Castro case against Peru, when the court specifically talked about the importance of gender approach of human rights violation. And I think this is important to understand this path because it shows us how the international standards has been incorporated or not in domestic cases. It was in 1996 with the Raquel Martín case against Peru when the Commission in the court released a report saying that rape, in some circumstances of the conflict, it was torture. And it was very important. But in 1998, the court released the case, the Loaiza Tamayo case against Peru. It was a woman who was accused of being a terrorist. She was before the court because she said that she was victim of torture and inhuman treatment and rape. And the court said that everything was proof but the rape. And if you read the Loaiza Tamayo case, the sentence, you will find the only argument of the court was that due to the nature of the fact of rape, it was not proven. But it was not a specific explanation of why it was not proved the rape. So after that, it was the Truth Commission report in 2003. And in 2006, like a plan, in 2006, the court released the Castro case. It was very important. Why? Because the court used the Parliamentary Commission report saying that sexual violence in the conflict is a weapon of war, that women were affected during the conflict a specific way, that forced nudity was a form of sexual violence, and all of this information that was very important to know. But it was in 2006 I'm thinking about all the other standards before the Inter-American Court, before the Inter-American system, before this case. So when you start asking judges that were in the law school in the 60s and the 70s and the 80s and the 90s, there was not this international standard. So this is important to know why to work with international standard. After this case, the other case that I'd like to mention is the Espinosa-Gonzalez case from 2014, when it was a woman, members from terrorist group of Peru. She was raped, and she denounced, she filed a complaint for the rape in the 90s. But the state never investigated. Actually, the state started investigation like 2 or 3 months before going to court, to the Inter-American Court. And this case is important because in this case, the court said that women that are accused of a crime have this special stereotype that nobody believes what they say, you know? And the court in this case not only is the operation, but also gave a lot of guidelines about how to investigate sexual violence cases, to protocols, what happened with rape, what is sexual violence, what is important to have gender. So I think it's important, and after that, well, this is the Peruvian case, all this is a Peruvian case, but on the other hand, we have the Mexican cases, like Campo Algodonero, Inés Fernández, Rosendo Cantú, important cases where the court talk about what is gender discrimination, mention femicide. It said that in the case of indigenous women, when they are raped, they are like racial, ethnic, and gender discrimination. All these standards are important. But I think it's important to understand also why the court took so long to start working with the gender dimension. Currently, there is some advances in the case of Peru because the Judicial Academy is supposed to establish a protocol and mandatory courses for judges on gender. This is still a little thing in front of everything that's going on there. I just mentioned the cases of sexual violence during the conflict. I'm not talking about the other cases of sexual violence in the everyday. I'm not talking about femicide. I'm not talking about all these complications, but I like to point something that I really mentioned earlier. It's about this importance to understand the continuity of the violence. You know, if you talk about, for instance, torture, you can say, okay, in the case of Chile, now during the dictatorship of Pinochet, you have the torture, the democracy, and the torture decrease. Or the forced disappearance in Argentina during the military government. After the democracy, there was not forced disappearance, and so on, so with massacres and everything. But in the case of sexual violence, you have sexual violence during the dictatorship and during the democracy. You have sexual violence during the war and during the peace. That's why it's so difficult to investigate. That's why it's so difficult to understand, and people think that it's like kind of normal that these things happen, and there are other crimes more important. And 2 other things. In the case of Peru, during the 90s, we found the cases, you may be aware of that, of the forced sterilization against indigenous women. It was during the Fujimori regime. Currently, there are more than 2,000 women, like from the 90s until now, asking to the prosecutor to file the report. More than 2,000. At only one part of the country, I had the opportunity to work on the Ombudsman office at that time and to file and to see the cases. But I need to mention is a story because like 3 years ago, something like that, there was a symbolic tribunal in Peru. You know this kind of symbolic tribunal? And it was a tribunal that had 2 stages. In the morning, it was supposed to be the women victim of sexual violence during the conflict, and in the afternoon, the relative of victims of forced sterilization that died in the sterilization. So we have this. I was like a special expert, you know, to talk about the obligation, but the story that I want to share with you, I think is a good example of what's going on. When the women victims of sexual violence finish and start the others, at the end of the tribunal, one of them approached to me and said, you know, Lisa, I want to tell you something. Yeah, I've been like 20 years talking about rape that I suffered during the conflict, but I just realized that I was sterilized as well. So I was raped during the conflict, I suffered a forced sterilization. And when I talk to the lawyer of these women, they say, she never mentioned that. So it's the same kind of continuity, it's the same kind of vulnerability, it's the same kind of victim. So what I think it is important to understand that, to talk about the standards, international standards, to think about how to incorporate that, implement that in the local work of prosecutors and judges. But I will always stress that it is important to understand this complex situation of victims of sexual violence. We don't have, in the case of Colombia, where Daniela or my son used to work, I remember many cases of women who approached to say, okay, we will rape, by the guerrilla or the paramilitary, so we have to go to this kind of judge unit, a special unit for that. But also we were raped by our neighbor, so we have to go by that. So what's going on there? So the thing is to understand that, and I think international law has this big, contribution with the standards. That these standards should be understood and teach with this continuity approach.
It up for questions and further conversation with all of you. And if you don't have questions, I have more. So.
Anyway, yeah, okay. Thank you very much for the great remarks on the gender elements of the international justice. In March 12, 2 weeks ago, the UN passed the first Security Council resolution about bringing back the UN peacekeeping forces from countries where the peacekeepers are accused of sexual abuses. The resolution was drafted and led by Ambassador Samantha Power. The US did a great job on that. Egypt said no to the resolution, passed 14-1. However, doesn't talk about accountability at all. Doesn't give jurisdiction to the local countries to prosecute those perpetrators. Doesn't put a burden on the national jurisdiction of the origin of these peacekeeping missions to prosecute those perpetrators. And in previous cases in 2015 and 14, when the French and Georgian soldiers were accused of raping or sexually abusing children and girls in Central African Republic, both countries said no, it wasn't really the true story and it's all allegations. The US continued, however, the financial support to Georgia. They gave them in 2015 $8.5 million in military aid, and the US could have simply used the Lehigh Law to suspend that support because the country is, or the military has human rights violations. So there is a move and progress towards basically recognizing sexual violence as a crime and as abuse. But when you see the international body, the UN is taking very slow steps, a step forward, 2 steps backward, unfortunately endorsed by sometimes by bad policies of countries leading the efforts on the positive sides like the US. How are we going to move forward with this? Thanks.
And then we'll take 3 or so.
We've talked a lot over the various workshops about capacity building and strengthening legal systems in various regions. And obviously this conference is very prosecution focused, but given what Professor Juan Mendez was saying about the importance of avoiding sham trials, I'm wondering to what extent this capacity building does or should extend to defense work of the accused perpetrators.
Hi, thank you very much. So I wanted to ask, I noticed in some of my previous work and studies on this subject, as well as on this panel and even a bit in this room, that when you're talking about gender justice, overwhelmingly the people who are speaking as experts are women. And on one hand, this obviously gender-based violence disproportionately affects women, and so in many ways this may be a really good thing in terms of speaking to victims and approaching this subject. But on the other hand, sexual and gender-based violence in conflict also affects men, and several of you have mentioned that gender is an intrinsic part of any crimes against humanity and any crimes on civilian populations as a whole. So I was just wondering, my question is, do you think that the fact that most people who are focused on gender-based violence are women is a problem in this field? And if so, what do you think needs to be done to address that? Thank you.
I'm Vicky Karimi. I wanted to ask about the investigation of crimes, of gender crimes after conflict, and in light of the new, of the ICC finding someone guilty of gender crimes, and wondering what you think about collecting evidence of sexual crimes and how the potential to collect pattern evidence instead of the way it has been done before. How do you see that happening more, and what collaborations would happen at the domestic level to enable the organizations to collect pattern evidence?
Fill out all of the questions to our panelists, and I think if you would like to take one or two, to go ahead and just jump in and do that.
Just to address your question about the UN Security Council resolution on sexual violence and peacekeepers, I think it's actually a very important step that this resolution was passed as a public acknowledgement of an issue that has been there for a really long time. It comes late. It's not a new issue that there has been sexual violence by peacekeepers in areas of deployment. So I think it's important that finally there's a resolution that the UN is taking steps, it seems more concrete steps to withdraw troops when they commit these types of crimes. In terms of the accountability, the way it has normally functioned up until now is that the perpetrators are supposed to be tried, and investigations are supposed to be carried out by the national jurisdictions that blame the perpetrators, and they're supposed to be tried domestically. So there's no like international mechanism to try peacekeepers.
To follow up on the peacekeeper thing, there was a very important report that came out. Deputy Prosecutor Jallo was part of the committee on that. One of the interesting things that finally the UN has done within this report is to remove just the focus on the sexual violence that peacekeepers commit as a disciplinary issue that has to be taken into account once they are back home in their jurisdiction, their home jurisdiction, but to also look at other employees of the United Nations to find out whether they violated a human rights duty or trust by not reporting sooner, by not reporting higher up their own chain of command. And so there's been a significant shift within the UN, but that's one of the steps forward. We have about 10 more to go until possibly the UN just declares a special jurisdiction that if you've agreed to become a peacekeeper, you'll be under jurisdiction of the United Nations in order to prosecute you for crimes or for the investigation. You know that gap has a lot to do with political will. And unfortunately, sexual violence prosecution has a lot to do with political will also. This is just an example.
I can speak to the question about the defense capacity. That's an excellent question. And I think it's absolutely essential to also focus on building the capacity of the defense. As I was saying before, there's strictly the capacity component and also the component of political will and institutional will. And I think both of those need to be strengthened certainly in the countries that my work focuses on. In terms of what we've done to try to protect defendants as well, there are a few different steps that we've been able to take, and there are definitely more that could be taken. One is that ABA really partners with bar associations, and in the DRC, a lot of the local bar associations are who's responsible for providing defense counsel, and they tend to have these, they call them Bureau de Consultation Gratuit, but like free legal assistance sections of the bar associations. The problem with capacity is not just the technical capacity to send a lawyer, but the resources to cover the costs of representation. And so a lot of the support that we give is training people in the idea of an equality of arms in court. So the idea that you need to have defense counsel who's equally strong to the prosecution, but also providing that logistical assistance to make sure that the defense counsel can be there through the duration of the trial. When we handle these more complicated sort of mass atrocity cases, often there's a memorandum of understanding with the different parties to a court case. Like in the Minerva example I gave before, there were a lot of international parties involved. And so before the case started, all of those international parties made an agreement about who would support which component of the case. The United Nations, MONUSCO, in the case of DRC, or UNDP, are often the parties that take on responsibility for providing defense counsel in those cases. So because ABA is acting as a victim's advocate, we can't, under Congolese law, support both sides of a case, but we can ensure that someone is promising to support the other side of the case, and we can say that we can't support the victim side unless someone is supporting the defense side. So these are some of the ways that we try to ensure that the defense counsel is also present. However, it's not enough. I think there definitely needs to be a lot more investment made in that political will side, or the institutional and personal will side, to change people's conception of the idea of a right to defense counsel, to make sure that that becomes sort of an established and anticipated part of a criminal case.
Well, you ask if there is a problem that only women are focused on gender. I don't think there's a problem. What I think it's a problem is that few men understand how important it is to incorporate a gender approach. And what is the problem is that in this case, are only lawyers and field lawyers who understand that. Because when we talk about gender-based violence and we talk about a court, maybe it's a space for lawyers, but not only for lawyers, because it was the anthropologists, psychologists, and many people who could contribute to the process. But the problem is gender-based violence doesn't finish with a sentence. You know, there's a big problem in the big part there. The other thing that I think it's important, I'm talking as my experience working with victims in the Peru Truth Commission, is when victims, women, don't talk about sexual violence, we got information from men. In many cases, women don't want to talk, feel ashamed. And the example that's very obvious, but I'm going to tell you, is, for instance, women who were raped during the conflict in the 80s, got pregnant, never told their husband about that, and then they say, okay, we are going to have a baby. After 10 or 20 years, they're not going to go to the Truth Commission to say, okay, this baby is product of rape, you know. This kind of situation, this kind of complexity is important to highlight, because we are living in societies based on violence in general. And another example is with criminal law. I'm going to tell an example about Latin American courts. In the case of Peru, for instance, before 1981, 1983, if a woman was raped and she married the rapist, this guy didn't go to jail. If the woman was raped by 3 or 4 guys, it was enough that she married one of them, but none of them went to jail. So this changed in 1981, and a traditional approach for men of women that's not with a gender perspective should be, well, okay, we change the law, everything is okay. No. What happened with this family that start after a rape? What happened with these societies when a woman was forced to marry the rapist, to have a child, to start living with this guy, and to start to caring and cooking and cleaning for this guy? So we're thinking about societies based in violence, and we're thinking about law like a way of legitimize this violence. So that's why I think it is important. It's not a problem that women are focused. Usually women, I'm talking about myself, and I cannot talk to anybody, approach to this because we feel that there is something wrong with the way that we live, that the way that they study law. For instance, when I was in the law school, I was raising my hand all the time, and the professor never picked the women, these kind of things that you think that's silly, but they're very important. But after that, you have to think that we are not talking about only a women issue. When we start thinking that violence against women and femicide and rape is not a problem of women, so not only women should take care of that. It's a problem of society. In the case of Peru, we have a very, very high rate of women who die for femicide. Every month, 10 women die in Peru because killed by their husband. So we have a big problem with that. So they're killing women in Peru. It's not a problem of us. I finished with this story. I was in Mexico with the professors in the law school. A lot of criminal lawyers. I was talking about that. And one is the criminal lawyer, the Mexican, raised his hand and said, okay, you know, you are family changing the law. Okay, now you have this special crime, femicide. So you're happy with that. And I say, okay, excuse me, but I'm not happy. Okay, it's not that we say, yes, they're killing our side, we have a special crime. This is not something that's making happy. This is a big problem, but it's not a problem only for women. That's why I think that more people should be involved in gender.
I'll say one thing quickly about that. And it depends on the models that we're using. Among the reasons that this panel and many of the panels that look at sexual violence are female majority is not because sexual violence doesn't happen also against men. If you really conceptualize it, even under customary international humanitarian law, you can terrorize the civilian population, and among the best ways to terrorize them, according to the Charles Taylor judgment, is to start inflicting sexual violence. And you might have specific victims that might be male or female, but what you really have is a community who is terrorized and might, in quotes, self-deport, such as in Kosovo. So if women, and I say, thank goodness, many feminist women lawyers have raised this issue. And after 20 years that we are having panels that are still female majority, it is thanks to this feminist approach to genderism that we're talking about an issue that affects entire communities, societies, males and females, whether they're children or adults. And we welcome any of the males, females to join us.
A few words as well on that topic.
With respect to the gender, prosecutor. In discussion of a high level, pretty likely. So, in licensing. Sexual violence. Other not really identified with
Just to follow up on that, there has been increasing focus on the issue of sexual violence against men, not only in the jurisprudence, but also at the policy level. And just to give you one example, I think just last month or 2 months ago, there were some guidelines that were produced by experts in the field, which are publicly available online, and they were compiled by the International Institute for Criminal Investigations in The Hague. And their guidelines focused on the issue of sexual violence against men and boys, addressed to policymakers and institutions at the domestic level to help them develop strategies to address this issue.
From a policy perspective on the question about defense lawyers is that I think it naturally stems from the fact of what donors fund. And I've seen a hierarchy of what donors want to fund. First is humanitarian assistance and psychosocial support. Down the rung is accountability and investigations. And then really at the bottom of the ladder is funding for defense work. And so I think in order to address the capacity problems that Amanda highlighted, that's something that we're also going to have to look at. And then maybe just the last question that someone asked about, as I interpreted it, best practices for collecting evidence, particularly at the domestic level. And I know that a number of you have experience there and insights there on that question as well.
That I always throw out a bit of caution of collecting evidence at the domestic level if you're not an officer of the court or investigator. And I really encourage people to collect it within their own natural capacities. If your NGO just collects information because you need it in terms of the services you provide, do it so that it becomes part of your normal business activity and it won't be attacked as much in court as evidence that's been fabricated for the defense or for the prosecutor. So we often come across what could become information for your own use and eventually evidence for a court's use, and that is completely fine. But to go out and search for evidence for a court, specifically on behalf of a court that might not even be set up, you just have to be very cautious of what you're doing.
We need to end in a couple of minutes, but maybe one other question.
From the Washington Office on Latin America and George Mason University. I was an observer to the Step Borsato trial in Guatemala last month. And one of the really interesting aspects of that trial was the use of video testimony by the women. Pre-recorded video testimony was introduced as evidence in pre-trial evidentiary hearings, and then it was simply shown in the courtroom. However, the defense lawyers, every single time the women were testifying via these pre-recorded testimonies, objected to the evidence and said that they were not having an opportunity to cross-examine. In the pre-evidentiary hearings, the defendant lawyer had a chance to cross-examine, but the accused had not yet been arrested. So these were just sort of, public defenders, and they didn't really ask very many questions. So the lawyer folks on this side of the island are asking me, well, what do you think? And I'm like, I'm not a lawyer. I don't know. So I'd actually like to get your opinion on the ability of courts to use this kind of pre-recorded testimony and what problems that might raise in terms of cross-examination or other issues that you might think. Thank you.
As a group, again, I think we actually have a few more minutes.
Hi, thank you for being here. I am from Venezuela. I'm a lawyer back from Venezuela, and I found the same struggles as Julissa Mantilla was talking about, like not being teach gender and stuff. And I'm wondering, like, question to you, I always find myself when I'm trying to argue why gender issues are important, why don't talk about general prison conditions, but women inside of prison conditions, for example, in my country. And there's always the general answer that, you know what, that's not, for now, it's not important. Because in Venezuela, we have so many different problems. And when you tackle the issue of gender, that's like, it's seen as a very minuscule, very teeny tiny problem. So I was wondering if you have struggled with this issue in your own experience, and what is like the advice you will give. Thank you.
Hi, I was wondering if you guys could speak to the complementarity efforts between the ICC and Guinea, and whether you think those have been successful thus far, and whether you foresee trials happening in 2016, and whether the national authorities will be able to adequately address the sexual and gender-based crimes that happen there. Thank you.
Okay, I'm going to start with you. Yes, I think all of us have the same struggles. And I just want to tell you a story about the experience in the Truth Commission, because when we started the Truth Commission in 2001, the general idea of the Peruvian armed conflict is that we have for disappeared, massacres, execution, but not sexual violence. Maybe 1 or 2 cases, but not sexual violence. And when we start, my team of the gender team start talking with the human rights lawyers, I mean the good ones, no? They say, no, this never happened. And when we talk about what happened in Rwanda, family, no, maybe it happened there. Because all the previous Truth Commission, talking Chile, Argentina, and the other one, never mentioned anything about gender and sexual violence. So after using the Guatemala report, that is very important, the cases of South Africa, we found some pattern, and we decided to use that pattern for investigating what's going on in Peru. After a lot of work, a lot of trial, a lot of messages like you heard, like maybe this is not that important, we have to focus on that, it never happened, that and that. We found after 2 years of working that we had sexual violence as a general practice in some spaces of Peru, and now the cases are going like crimes against humanity in some cases. What I want to mention is that since nobody teaches gender in the law school or the other schools, you have like start creating these tools. We start creating things like, for instance, what is going on with the massacres. And I say, okay, nobody count how many people, men or women. So we start counting different, we start talking with men, we start to developing a lot of tools. And the real issue there, what's important for us, and I always tell this, is that if the Truth Commission didn't incorporate this gender approach with all the problems, with everything, now we couldn't have the cases of sexual violence. But the important thing there is to start from the beginning, you know. So you didn't understand or you didn't study nothing of gender in your career, you're not going to have that. That's why the lawyers or the judges, for instance, the Inter-American Court say, you have to investigate with the gender approach. And they say, okay, how to do that? Call some families to teach to us, or women. That's important things to know. But I think in the case of transitional justice, in the case of Colombia, I recommend to read because there are a lot of work. And I'd like to mention something about collecting evidence. I totally agree with Patty. And in Colombia, remember in 2002, when the Peruvian Truth Commission was in the middle, we had a meeting in Colombia. And I remember women from the organization, from Women Peace Initiative, all these organizations that say, we are never going to have a Truth Commission, we are never to have that. And I remember telling them, start documenting, start talking with women, taking testimonies, they are listening and we are demanding that you listen. Because when we started in Peru, we didn't have anything. Not a single report from NGOs of women, not a single report from human rights NGOs about what happened. So we have to start with nothing. So we told the Colombian women to start, and they said, maybe we are going to have a Truth Commission. After 12 years, we are going to have one. But the important thing is there is to there's different way of collecting evidence for court, for trial, but the other thing is to collecting testimonies, to talk to women, to understand, to be real, because when you have this transitional justice mechanism of reparation, reconciliation with a male approach or without a gender approach, you just get used to something that is, everybody's asking for that. But when you start talking to women, but never talk in public spaces, you start understanding the different ways of having this. I met some women in Colombia, they were raped, they have children, and they lose the children because somebody took. And when they talk in spaces with trials, with people talking about what they want as reparation, they say, we don't want this guy to go to jail. I just want them to tell me, where is my children? So this is important, and one recommendation that I always say is start talking to women, ask the women, and please learn to listen. Sometimes you say, no, women don't want to talk, we don't want to force them to talk. Okay, the important thing is to understand that It's not that you force women to talk, but when you don't learn how to understand, you're denied the right for them to talk. When we were in the Truth Commission and we were dealing with sexual violence and that, and we started, it was a people working on the reparation. Some of the people say, okay, we're going to have the chapter on sexual violence, but reparation, how to reparation for rape and for nudity. We don't know how to do that. And our answer was, if you don't know how to do that, shame on you. Please learn about how to do that. But you never, this is a humble advice, never should have said when people say, we don't know how to do that. You don't know, you have to learn.
In terms of the question on Guinea, I'm sorry, I can't give you any information. Of course, we're always hopeful that the process is going forward and that the ICC will be able to do its part of the prosecutions and that Guinea will also be able to do its. A quick question in terms of the filming, using documentary filmed evidence prior to an accused being arrested. There are provisions at the ad hoc tribunals to enter into evidence, at times statements or transcripts that come from other related cases, but they have to be specific to issues, not that the defense would necessarily want to have contested, maybe a type of jurisdictional issue to say that these people come from a geographical location. But of course, the defendant, once arrested, should have the ability to cross-examine any evidence that's presented to the prosecutor to say that he is liable or responsible for certain underlying crimes. So we'd have to get to the nature of why that evidence or those films were submitted.
On the question of Guinea and complementarity, I can only speak about it secondhand through colleagues who are working there. There have been quite intense efforts over this last year and a half to support the building of domestic capacity to prosecute sexual violence crimes. And one of these initiatives has been led by Senator Rawls' office, a team of experts on sexual violence. In that office, it has deployed an expert to work alongside judges in Guinea to help them investigate these crimes. They are, of course, confronting very serious issues. For example, not only are the victims and witnesses in the cases subject to security concerns, but the judges themselves who are involved in the investigations have been subject to threats from accused persons and persons associated to the accused. And there have also been issues regarding the applicable legal framework to these crimes, and there have been recent reforms to try to incorporate some of the international standards and international crimes in domestic procedures. And now the question is, do these new crimes apply retroactively or not to sexual violence crimes that happen there? So there are efforts, whether they're going to result in prosecutions or not, as Patty says. Well, of course, hopefully will, but it's just a still question that remains open.
All right, I think with that, our time is up. I think we've seen that we've made incredible progress over the last 2 decades, but still have quite a bit of work to do. So thank you for everyone's participation and for our panelists.